All right. Well, welcome everyone. Good afternoon, I guess it is now. My name is Mark Palmer. I'm Chief Counsel at the Commission on Professionalism. I'm joined by our Deputy Director, Stephanie Volinsky. You have a 2-for-1 special today for us to talk about civility in the courtroom. Although we'll be presenting virtual today, I hope everyone will be engaging with us and learning along the way. I'll quickly introduce the two of us ourselves if I can get my slides moving. Let's see. Easier said than done. Come on now. It worked a minute ago. There we go. Well, I'd like to introduce Stephanie Volinsky. She's co-presenting with me today. She's joined the commission. Uh, how many years now, Stephanie? 7?
Seven,
Yeah.
yes.
And prior to that, she was the content director over at Illinois Legal Aid Online, which I'm sure you've all heard of, one of our great resources we're lucky to have in Illinois. Before that, she was a litigator also with Legal Aid Chicago and a community justice project in Pittsburgh. She went to school at St. Mary's College and DePaul here in Chicago for law school. Stephanie's a nationally recognized leader, of course, in professionalism and civility. She's chaired the ABA Standing Committee on Professionalism and been appointed by 3 ABA presidents to serve on its Cornerstones of Democracy, Civics, Civility, and Collaboration Commission.
Awesome. I will do the honor of introducing Mark Palmer, who's our chief counsel at the Illinois Supreme Court Commission on Professionalism. Prior to being at the commission, Mark graduated from the University of Illinois, and then from now what's called UIC Law here in Chicago Law School. He's been an adjunct professor at the University of Illinois and has taught trial ad and coached their trial teams for over a decade. And prior to joining the commission, Mark was in private practice as a litigator in Champaign, primarily focused on commercial litigation, banking law, and municipal law in state and federal courts.
Thank you, Stephanie. So our goals today for the hour we have you is to talk about 3 main learning objectives. How civility impacts the legal profession. That's kind of the 1,000-foot view perspective first. Then we're going to specifically turn to the litigation process, not just in the courtroom, but the process as a whole and steps involved in it. So hopefully most of you are litigators. If there's some transactional attorneys, don't worry, there will be some applicable takeaways that still I think will be helpful for you along the way. And that's the third component. We always want to have tangible, useful takeaways that you can return and use today, starting today in your practice to be more effective from your communications, be it with your clients, your opposing counsel, in your writings, your pleadings, your emails, and so forth. To do that, to keep you engaged, and I understand if you need to eat your lunch or hopefully you're not driving in the car, but you might be. We understand if you want to keep your video off, please feel free to turn it on if you can. But more importantly, stay engaged with us using the Slido tool. If you haven't used this before, don't panic. It's very simple. All you can do, the easiest way probably is to pick up your cell phone, your mobile device, point it at the screen, just like you've ordered at restaurants for the last 5 years, and hit the QR code, and that'll take you directly to the polls, the questions we have throughout this presentation. The other alternative is to go to Slido's website. You can do that either on your mobile device or right parallel on the side on your computer. And this will be the code to enter at slido.com or app.sli.do. Also, don't panic. This QR code and code will come up each time during the event. So I see some things in the chat. Oh, I missed the code. Don't worry. The code will pop up anytime there's a question. So you can go ahead and pick up your phone and try it then too. So let's dive right into that. Stephanie.
Sure. Thank you. And thank you so much for having us today. As far as the Slido, yes, again, on the corner, and some of you are already working it, you have the QR code. And then if you go to slido.com, the number 2. And so we're going to start off with just getting kind of a overview of your thoughts as to what extent you think incivility is a problem in the legal profession. So it's just a multiple choice question using Slido. All right, significant is is coming up strong. Um, all right, you can keep doing that. All right, it looks no one is saying it's not a problem, which is probably a good thing we're here today then, right? All right, excellent. Well, I also want to get into, our actual, thank you for this data. Want to get into some other data as well that talks a bit more about this. So the Commission on Professionalism, we perform surveys all across the state on issues of bullying and civility, et cetera. Our last civility survey was done in 2021, and here's a bit of the data that really stands out from that survey. So of the 54% of attorneys who said that they had experienced incivility within the past 6 months, the incivility really broke down into three components. It was strategic incivility, rudeness, and prejudice. So the biggest one was strategic incivility. And when I say strategic incivility, it's really, the acts of misrepresenting facts, negotiating in bad faith. And so this obviously was the one that people, felt they've experienced the most. On the rudeness category, how it was really defined there is really getting into things like, condescending tones, sarcastic responses, etc. And then the other big category was prejudice, and this really includes everything from ageism to sexism to racism, and unsurprisingly, women and people of color are the were most affected by this type of incivility. And so when we looked at where does this incivility most occur, the main areas, the practice settings seem to be in the legal aid and nonprofit sectors, and then the types of practice of law that are most prone to it. Probably not a huge surprise on some of these, family law, criminal law, etc. So that gives you a sense of where it's at. And then in addition to our civility survey, I wanted to show a bit of data from a national survey. And Mark, thank you. So this is from a national survey on civility in general. So this isn't just geared towards the legal profession like the commission survey was, but this was, you can see here kind of the groups that were most impacted, and definitely can see here that it goes in line with some of what our survey found as well, that people of color, women, those, LGBTQ people with disabilities had higher rates of experiencing incivility.
So these conversations and the survey elements didn't ask only what was happening out there in Illinois throughout the state. It was also how it was consequential to their practice as attorneys. And as you can see, there's a wide range of reporting of high impact costs to both the client, the efficiencies of practice, and even financial costs along the way, but also costs to enjoyment and how they have confidence in the judicial system, including the public's confidence, even outside the legal practice. So take a moment and review the high numbers of percentage reported from our respondents of agreeing or strongly agreeing with these consequences around how incivility impacts the difficulty to resolve matters, the cost to their clients, and of course, the delays and prolonging of resolving matters, and usually in the discovery process as well, parts of that. So we've outlined kind of the background on what lawyers have experienced, and I want to hear from some of you, if possible, if you don't mind. I think even as we introduced what we're going to talk about over this lunch hour, probably some specific instances in your past, in your practice, popped into your head. And if anyone's willing to come off mute and say, without naming names, if you have any specific examples that are very brief that popped into your head, I'd love to give you the microphone for a moment. If not, I can certainly tell you about some of mine in years of practice. Any brave takers? Well, while you're thinking about it, a lot of my early days in my courtroom experiences centered around experienced attorneys taking advantage of both writing advantages and oral argument advantages. And what I mean by that is, in writing, there was times when they would try to sneak in and negotiate in bad faith, back even the days when you had to hand write out your orders right there in the courtroom before the electronic e-filing days came upon us, trying to sneak in terms or things that we had not agreed to, or that the judge, frankly, did not even address in the courtroom, thinking that because I'm a green associate, I wouldn't overlook it, or I would overlook it, or look past it, or trying to bully their way into getting an extra advantage for their client in those types of circumstances. That's one kind of softer way, but highly, of course, inappropriate and in bad faith. Um, Another way is the arguing aspect. And you've seen some instances where opposing counsel may turn to you and argue to you. And sometimes a judge won't correct them and say, counsel, this is an argument for the court, not to opposing counsel. And I think that shows where the arguments are going in the facts and application of law that they're actually telling the court. But if they're turning it into a personal vendetta against opposing counsel, or trying to get those little jabs and bars in that are directed to a personal trait or attribute or experience or the like, that is directed to an individual and not to the issues of the case or what's at issue, why you're there in the courtroom for the day. As just a couple simple examples. Yeah, another a couple examples in the discussion about, and I've seen this where the actual pleadings themselves, and we'll talk more about this, have included specific references to how people are referenced, either how they're described that are inappropriate or otherwise. So let's start thinking about what are the strategies then to address this. And we asked that also in the survey because we wanted to see where the lawyers were pointing to seeing the top responses to how to address professionalism and civility in solving these problems, or at least improving them along the way. And a lot of those top responses involved judges, empowering judges, or at least training the judges to appropriately take enforcement measures into their hands in their courtroom. But of course, judges can't be everywhere. They can't be in the hallway conversations. They certainly can't be in the discovery process at all points. Maybe in some points they can, but not in all. And not in all email correspondence, pleading filings, and so on. So there is that aspect of judges are asked to take on a more proactive role, and that's certainly commendable. But that's not the end-all solution to these issues overall. And the commission does do a lot of judicial trainings, both for new judges and experienced judges across the state, to address these issues. But there's other strategies involved, as you see listed here, that can even start as early as the future lawyers, right, in law school. And there's only so many hours in the law school training curriculum that's available to include issues of civility and professionalism. But we are certainly of the strong mindset that those can be an element of the ongoing substantive law you're learning in law school to come out as a civil practitioner from the beginning. And other types of training methodologies, such as mentoring through our mentoring program for those new lawyers in their first 5 years of practice, is a great example of getting them paired with the right type of practitioner to show them the ropes, especially when they're solo practitioners or in small firms where they may not have many opportunities to have those discussions with senior counsel or experienced attorneys to lead them in the right direction. let's specifically turn to some of these instances along the way, starting with emails with opposing counsel. And to do that, we're going to start by looking at a series of email exchanges that actually became the subject of a real ARDC complaint. This email is an exchange between a male attorney who is perpetuating incivility, that is Attorney Johnson, and Attorney Renwick, who is the victim of the incivility in this instance. And Attorney Renwick is a highly respected Black woman who practices family law, just to give you some background. And this is a part of the overall ARDC complaint, but this is just a segment of that to give you a feeling for the exchanges they had throughout their history. And it began with Attorney Rendrick, the victim, sending very routine email, right, to counsel, exploring the opportunities for settlement. And I'll let you pause and read these for yourself. But she sends that, notice the timestamps, early in the morning, 9:14 a.m., and 12 hours later, late into the evening, is when the replies come in, and replies that are very inappropriate in and of themselves. And immediately going into referring to a social event as well, that emphasizing that she should not be invited to this event, or you're not invited. And that continues, the exchange continues, where Attorney Renwick responds that, well, she is invited. This is an old friend of hers and former professor, and she has an invitation for it. And I'll pause and let you read through the rest of this. So as you read that, you certainly get a feeling for the tone, the attitude, the uncivil behavior, and inappropriateness that we've already steered way off course of any appropriate legal discussion around the initial question, right, of settlement opportunity. Very inappropriate. And this continues on even into late into the evening, as we see. And then we see the Attorney Johnson bringing in, CCing the law school dean, friend, old professor, that is of discussion even. Quite remarkable. So let me turn the question to you. You are Attorney Renwick. How do you react to this? What is your next opportunity to take action? What's appropriate? I'll give you a minute to think about that and enter your answer. While you do that, I'll also give you a little bit more depth into this actual ARDC complaint. These were just some of the emails mentioned. There was much more. There was also multiple pleadings targeting both Attorney Renwick, her client, and even the child involved in the case, which even included the attachment of a photograph of the child into the pleadings. Eventually, the suspension, the Attorney Johnson was suspended for a 6-month period, but that suspension was stayed for a 2-year period of conditional probation, which included educational courses on misconduct and so forth. And it was discovered, and this is public knowledge as part of the ARDC process, that Attorney Johnson went through therapy and treatment for what was untreated bipolar disorder, which accounted for under the filings explanation for some of this behavior. So looking at your answers, certainly only a few of you went to ignore it. If you did check if you had other concepts, feel free to put your ideas or what you were thinking into the chat. but the most of you would advise that it's unacceptable. And so what are some strategies to respond to this? Well, real briefly, I think it's always wise to pause before responding, have a cooling off period, even whether it be an email. We often talk about responding to negative online reviews in the same type of capacity, right? Take a breath, maybe even wait till the next day if it's appropriate, but sometimes you don't have the luxury of time to wait and respond to cool off. But that doesn't mean you can still rise or lower yourself to their level in your response. Also focus on the argument itself and not the person. So phrases such as, I just don't agree with your position or description, that attempts to realign the focus to what should be at hand, the actual issues of the case. In this case, or in the example we saw, is there a possibility of settlement discussions, right? And put those responses in there. Be brief, be to the point. Also send them during working hours, right? Usually emails sent late into the night, unless it's a very justified emergency, usually can wait till the next day and should many times wait for the next day. But also think of all emails ultimately becoming exhibits to pleading. Like I always say, use the front page rule. Never send something you wouldn't mind being posted on the front page of your local paper. If it meets that test, you're probably safe if you have a high level of judgment.
Thanks, Mark. In addition to emails, I think we also definitely experienced some incivility on telephone calls, and you may have experienced the yelling possibly from opposing counsel on the other end of the line. You might have been involved in that yelling as well. So let's take a quick look at a hypothetical related to this. So I'll briefly just kind of read along. Attorney Anderson was assigned a new housing case where the client had a clear defense to the eviction that was filed against her. And counsel for the other side is Attorney McWilliams, and attorneys Anderson and McWilliams often litigate against each other. And therefore, Attorney Anderson called up Attorney McWilliams just to discuss the client's defense and state that this was an obvious defense to the eviction, and so would they be willing to just go ahead and dismiss the case. And Attorney McWilliams raising his voice and really starting to yell back to Attorney Anderson that the case isn't up till court until Friday. It's only Monday, and I know that legal aid attorneys have all the time in the world to think of these defenses, but those of us who are being paid have a lot of things to do, and so tired of you taking advantage of the system. So what do you think Attorney Anderson should do in this case where there's a clear defense, trying to just have an agreement on that to dismiss the case, getting this response from Attorney McWilliams? Go ahead and put some, those thoughts in the chat. What would you do in this situation? Yep, exactly. Yep. File the motions. Yeah, file the motion to dismiss. Yeah, I like that, Stevens. Stay focused on the issue. I think that's a key thing for a lot of these things, just really focusing on the facts. Yep, mention the phone call, even go into sanctions. Yeah, no, these are all great. Yeah, exactly. No, these are excellent, and really, you can obviously document the conversation as well. But Yeah, I like that, Jonathan. Yep, exactly.
Hmm.
Exactly, yes. No, great answers. Thank you. Thank you.
For those of us that know Jonathan, we know he'll speak his mind, as I do. Well, let's turn to pleading. Some of you have mentioned pleadings. Let's look at that. And in fact, we can go back to the same example of Attorney Johnson in this real ARDC. This is Illinois ARDC case. I think someone asked what state it was. It is Illinois. Um, in this case, take a look at this segment of the hypo where it discuss filings, pleadings. So here you see these things in a motion filed by Attorney Johnson opposing counsel for your case. Kind of similar to Stephanie's example. How are you going to respond to this? What are your options? Maybe from a low end to a high end. Uh, what are your levels of options that you see in this types of situation? Give you a second. You can also please put that in the chat. Yeah, this is an emotion. The quoted bullet points are things that were filed by Attorney Johnson in a motion. Yeah. Yeah. Motion to strike. And I think that's a good point that it does depend on the judge and your experience with the judge and the judge knowledge of the parties. Sometimes it does come down to human relationships and backgrounds. Doesn't make it any less unexcusable, but how you're going to address it may be a factor to those situations. Very good point that sarcasm does not come off well in writings, be it email or pleadings or the like. So obviously some motions to strike it as you have seen Rule 137 sanctions possibilities there. But it certainly is a violation. And could it be something that would rise to the level of filing an ARDC complaint? Well, ARDC complaints, as we know, must hang their hat on violations of the rules of professional conduct. That is literally their jurisdiction. And so, what would be the rules in this case for such conduct? Well, I think a couple of them are certainly applicable. First, 4.4 is one of the rules that involves respect for third parties, respect for the rights of third parties, and that is applicable to a lawyer and the incivility towards another lawyer. So, because opposing counsel would constitute a third person to whom the lawyer must show respect and cannot seek intentionally embarrassing them or burdening them, that's one opportunity, certainly. It's often, of course, when evaluating misconduct, look to 8.4 and the various subsections of 8.4. And I think a couple of them apply. One on the screen would be D. David, which talks about the more broader aspect of prejudicial behavior to the administration of justice. And the comment 3 kind of expounds on that. There's also, as many of you should know, 8.4J that was amended just last year to include addressing sexual harassment, providing definitions of harassment and discrimination, and imposing a know or reasonably should know standard on lawyers for certain harassing and discriminatory acts. Before that amendment, they were very limited to violations of law, and now they're much more broader aspects as defined under 8.4J. So to dig a little deeper in that, certainly invite you to dig into some of the resources from ARDC specifically on that. But just to kind of turn to the rules themselves when analyzing your opportunities and how you evaluate the seriousness of the conduct against you and how to bring those to the attention, be it of the judge or a regulatory body, these are the things you could hang your hat on.
All right. And then moving into the courtroom, now taking the pleadings into the courtroom, in civility from opposing counsel, during hearings. So I'll run a hypo by you, related to this. And it focuses on attorney Michael Ray, who's been really practicing for over 35 years. And then attorney Joy Fisher, who's been practicing for just under a year. They've never had a case together, first case against each other. Attorney Fisher enters the courtrooms for the status, and Attorney Ray approached her immediately, with his draft settlement agreement, and shared it with Attorney Fisher. Attorney Fisher looked it over and saw that numerous things were missing that were important to her client, in the settlement agreement, and she pointed that out to Attorney Ray, who, in open court, in front of everyone, judge, and everybody else, obviously, really going after her for, being a younger attorney, not knowing what she's talking about, recommending, a mentor, and that, this is the best offer, she's going to get. And so what would your advice be to Attorney Fisher in this situation? And we definitely saw in our civility, study that there is obviously, and we've probably, as you remember when you began practicing, there is definitely that sometimes imbalance of, attorneys have been practicing a while and younger attorneys. So what, if you were, mentoring Attorney Fisher, what would, be your advice to her? And feel free to put that in the chat. Yep, file a complaint. Exactly. Exactly, stand your ground. Yeah, for sure. If they're gonna go up in front of the judge, I'm sure Attorney Ray is going to say, well, I've got the settlement agreement that, she's not gonna enter into. Right, I think kind of going off what the comments are here, I think Attorney Fisher can easily say to the judge, I obviously want a settlement agreement here too. There are a few things that my client still needs, and want to work through those. Yep, take a breath. Yeah, exactly. People will be people, kind of, Robert, for sure. Um, yes, I think those are all great. I think once she gets back to the office too, if she wants to formalize what's missing, send that over. And I think that, obviously, I think another option might be, she could obviously talk with a supervisor, probably have a colleague come next time to court, just so she, there's someone else to kind of witness, some of the behavior. But thank you to everyone. Those are, great examples.
Well, let's continue the litigation journey. And
Mhm.
certainly an element of the litigation journey that unfortunately too often involves uncivil behavior is the deposition, right? We don't have a judge in the room. We may be able at times to get a judge on a phone call or otherwise get in touch with the chambers. But for the most part, it's up to the parties to self-regulate themselves. And I think it really starts off with how you set the tone walking into that room and how professional you can be with each other from the get-go. Again, let's look at a real life hypo. You may have heard of this hypo. It was just a couple years ago, but it got major national attention out of New York. And I'll give you, this is a summary of what went down. But in general, it's kind of basically an overall deposition gone bad, as you can imagine. Uh, Inappropriate interruptions, inappropriate and improper based objections, consistently improperly instructing a witness to not answer questions time and time again, all peppered with abusive and bullying behavior throughout, inappropriate comments to counsel across the table continually. So because of this, and because it was reported to the judge, as you read through all the all the bad behavior that happened here. Um, the judge came down on these lawyers with lots of sanctions and lots of responsibilities because of their uncivil and obtrusive, quote unquote, behavior throughout that deposition. And she gave them multiple orders, including that the lawyers reimburse the defendants for the cost of such deposition, that they were fined or required to pay a collective amount of $12,000 to the lawyers' fund in New York, and again mandated to take CLEs centered around civility. And this is what really caught my eye, that the deposition transcript was to be part of the seminar and used as an example of uncivil sanctionable behavior. Wow. Right. That's something. So I want to think back for you. What has worked well for you to proactively address issues of civility in a deposition situation? Whether you are a new attorney, whether you're experienced, what has worked well for you? Here's some strategies that I've discussed over the years. If needed, consider a protective order or conducting the deposition by video. Video, which is much more used in modern times, does seem to add an added layer of accountability to the environment, right? It goes a little bit beyond just having that court reporter in the room, which is something of itself, but having that camera lens pointed at you, pointed at the room, takes away to a degree that element that wasn't previously captured by a court reporter at all times, if you know what I'm saying. The certain amounts of tone, the certain amount of facial expressions and the like, right? Those things can't always hide from the video camera the way they could hide from the court reporter, which is interesting. Obviously have proper objections ready to go and understand the rules of how depositions work is important. And I would say most important, set those rules early, or it may at least repeat the foundational aspects of how depositions should be run. And in doing so, you're doing it not just for opposing counsel, but of course you're doing it for the clients as well. It may be their first time ever doing a deposition. And some lawyers may be more green of doing depositions as well, or haven't done one for a few years and need to be reminded that this isn't the same as a courtroom, that there are different rules and how it operates, and they need to be reminded of that. So be prepared, and just like a judge can set the tone and rules at the beginning of a hearing, you as the lawyer can now help set the tone and rules for the deposition, right? And if needed, call the judge. And that's not always possible. I understand that. But maybe if you know that it's going to be a difficult deposition for whatever reason, maybe you can proactively queue up the judge to some degree to have him or her ready, right? Have him on hand, her on hand to be ready in case there is a need to call them up. Okay. Again, if you have other things I haven't mentioned along with this punch list, please throw them in the chat and let's learn from each other along the way too.
All right. So moving to incivility from judges during hearings, I think some of you have definitely already added this into the chat. I think we'd like to think, that yes, though, the judges should be keeping the courtroom civil, but at times we have seen obviously that it's not always the case. And so, what do you do in a situation like that? And so let's take a look at this hypothetical. So Judge Jones is frequently known for interrupting attorneys, presenting their arguments. Interruptions are typically not for clarifications, but really more in a dismissive and rude nature, making it challenging for attorneys to present their cases effectively. An example of this would be a younger attorney asking Judge Jones if she can respond to opposing counsel's rebuttal position. Him visibly rolling his eyes and sighing audibly, go ahead, we don't have all day. Do you see how busy my courtroom is? And so If you were going into, doing a preparation for a hearing with Judge Jones, what would be some of the things you would kind of have at the ready, or how would you advise another attorney to prepare for that? And feel free to put that in the chat. Yep, exactly. Have the court reporter for sure make the record. Um, yeah, I would definitely advise the younger attorney in this situation that, saying something to the judge, yeah, briefing schedule, saying something to the judge like, I have a few more cases to get in, and I, just be a short while, judge, and get those in. Obviously sometimes there's not the court reporter. I remember in my legal aid days, always can do the bystander report as well. And again, really kind of coming back to focusing on, advocating for your client. I think, it's easy in situations like this, especially when, excuse me, tensions get high, there's a power imbalance, but really remembering you're here to advocate for your client, and do all of that.
Can I say a couple things, Stephanie?
Yeah, yeah, go for it,
One
Mark.
is not uh, in more and more courthouses I've found, and I'm down in Champaign County, and I know it's true in our courthouse. Even if there's not a physical court reporter in the room, every courtroom, when there's active cases going on, it is being recorded still by devices in the room. So just because there's not someone present, many Illinois courtrooms are having more additional, live transcription devices recording what's going on in the room, and they're very good microphones, very good recording devices. So, worst case scenario, just because a reporter was not there doesn't mean you can't get a record somehow, in cases where it's needed. That's one thing. Another thing is, some jurisdictions, whether it be through a local bar or otherwise, do have ombudsman programs, and that can be an intermediary between the lawyer and the judge, or the lawyer and the chief or presiding judge if needed, to bring things to the attention, right, of somebody above that judge, to give them advice, give them a little bit of steering, or even worse, give them additional educational training, or further bring it to their attention, and do it anonymously through that ombudsman. So, because many times what that attorney is appearing maybe daily or weekly or at least monthly in front of that judge. And so they're put in a very difficult position if they're going to be personally having to take action to address what they would consider different levels of varying behavior from the bench. But they still need it to be rectified, or at least addressed by some authority that may not be the level of a judicial inquiry board, right?
Oh, great points, Mark. I do think, a great point in the chat too. A couple of you have said, answering bar association requests for references for the judge. Also, I mean, keeping in mind, the arguing with the judge, obviously you do run the risk of, contempt. So, I think keeping that in mind too, but I think a lot of these are great suggestions, that are really, I think, could really help in this situation. So then we also have, probably some of, when we talk about civility and professionalism, a lot, we get a lot of comments from attorneys that a lot of it is often driven by the client. And so, I think that is something we want to make sure to consider here as well. And in this hypothetical, we're just talking about, obviously we mentioned family law being very contentious. This is a divorce proceeding. Opposing counsel's requesting 1 week extension of time to respond to discovery on account of a death in the family. You advise your client, but your client insists that you refuse to grant the extension. And if the client says, I'm not going to do anything to make this process any easier for my wife, when opposing counsel, files the motion seeking an extension, your client insists that you file an objection to the motion. And you really advise your client that this violates the norms and courtesy of professionalism in your jurisdiction, but your client still remains unmoved, and then obviously begins to start making the suggestions. Well, maybe you're not the right lawyer for me. Maybe you need to be tougher, etc. So what would you do in this situation, or even if you have another situation, with that you've had with clients withdraw? Yeah. Oh, thanks, Mark. I forgot there was a Slido on this one. So yes, go ahead and answer. This is a multiple choice one.
I think this is a difficult one to pick the best answer because it is very
Yeah,
subjective to the situation. But it gives you some ideas.
yeah, I do. Yeah, agreed. And I do think definitely starting to talk to them about how this might impact the case going forward. Should you need to have an extension for anything. And really, I do think setting the expectations up front is really crucial to the. Interesting, Robert, on your situation there. Okay. Yeah, this is definitely not, there's more, not one single answer here.
All
Yep,
right.
I know, Charles, good point. I actually was thinking that as well. But you might not be the right lawyer for him. Mark, were you gonna add something?
I was just gonna, what comes to mind is I think we'll see more and more use of limited scope representation agreements. And now that that is fully allowed in Illinois, and some people say, and rightfully so, the courts sometimes need to be educated that it is allowed, because I think sometimes judges uh, don't allow it when they should, from what I've heard from practitioners. Um, but there may be situations, including in litigation stages, that you are limiting your scope, and that is perfectly allowed by the rules, if they're followed appropriately. And it's part of, again, building that early conversations with your client and setting limitations when it's appropriate in that type of representation. Let's turn back now to the judges themselves. We've talked a lot about judges, good, bad, and ugly portions of what they can do in solving the civility issues in our profession. The lawyers in the survey put a lot of weight in the judge's seat on the bench and addressing those things. Um, and and like I mentioned, we do a lot of presenting with uh, the AOIC and other types of circuits and so forth for both new judges school and ongoing judicial trainings, to share that role and responsibility. And I think just like it starts with those early conversations with your clients, I think it starts with how judges set the tone and context for their courtroom, because there's not always rules in place that they can point to that are applicable for all situations. But consider the context, the severity and frequency of situations that they can call upon in court when it is an in-court action that they are personally observing. Then they can react to it right then and there. And I've seen this done in instances in occasion where, be it of counsel, be it of a self-represented litigant, or even of a witness or other person in the courtroom to be literally put in timeout. Give them a time to go out, bring themselves back together once they've calmed down and are able to hold themselves in a respectful manner. They may re-enter and re-engage with the courtroom. And judges have control to do that, but I think that starts with setting the expectations from the beginning of that call. That's very important. So how do they proactively address that is the key component and takeaway there. What other practices have you seen? We're kind of getting close to wrapping up our hour discussion here. What have we not mentioned that's helpful for you in litigation, and whether it be in writing and whatnot? Throw something in the chat. We're happy to engage with it. I love that you're making engagement letter is a key component of that. And I think I would put that on a 6-month review of how you have an internal process of that engagement letter, right? A lot of us just have that same one you pull out of the file every time, but are you actually setting aside a time to dissect that and update it properly with all the things you're doing? For example, are you using certain technologies in this day and age? That might be a valuable and even required component of your representation that you want to mention in that. And otherwise, look to your malpractice carrier to say, do you have any recommendations or ideas that I need to be putting in this engagement letter? Things like that. So right out of the gate, you're setting the tone of not only what the representation is going to be, but also using that, frankly, as a marketing tool, right? That is a great way to have that connection with your client so they know, yes, this is a thorough, competent, responsible lawyer who leads with professionalism. And this is demonstrated to me right out of the gate with this agreement. That's quality. Yeah, I love that phrase, and we use that often. Disagree without being disagreeable. Very well put, because civility is not the absence of disagreement, not the absence of conflict. In fact, the opposite. Many of us argue our democracy is based on disagreeing and having different positions, but being able to issue spot and argue those professionally and civilly.
All right. Yeah, pick your battles. I just saw that's a good one as well, to keep in mind. I wanted to just briefly, kind of towards the end here, I did see early on when we were talking about incivility, I did see someone write down alcohol as one of the reasons why for that. And I just wanted to just briefly mention just really well-being issues of handling some of this, the impact of some of this. Obviously, we know that being an attorney, just in general itself is a stressful, job, especially stressful, during, certain moments, especially when trials, et cetera, work antes up. And so that alone is enough there with stress, but adding on the incivility that we've really talked about during this hour really creates even more stress, and really, easy to begin to deal with that, in some, ways that aren't the best. And after time, those can really build up. So, just some things to kind of think about, in your kind of everyday, everyday world and practice to kind of put in place so that, those things to have some things to deal with some of this, and I saw a lot of you throughout, which is good. There's laughing is a great, great medicine for a lot of this. I think one of the big ones too is just being realistic about what you can get accomplished in the case as well, and remembering a lot of, all of this, most of this happened before you got involved with the, the client, and it's going to perhaps continue after your involvement is through. So kind of trying to just keep that in mind. The setting the expectations up front, I just want to reiterate that again, even with Mark's talking about technology. I mean, it's so different in terms of ways to communicate. I think having upfront conversations of how, when will you get back to the client, how best to communicate with the client, are you gonna, take text, etc. I think being upfront about that, I think really does help to set some of those expectations. I think too, remembering prioritizing time with those outside of the legal world and helping to remind yourself, yes, you're an attorney, but you have an identity beyond that. And some other easy ones that are really good are, don't skip medical appointments. I think that's, I think we tend to easily say, okay, cancel that dentist appointment, cancel that doctor's appointment, and you just keep doing it, right? And it builds up over time. And I would just, the last thing I'll just add is, with all of these situations, I think you're going to know, like, you're going to know the judges, you're going to know the opposing counsels that are going to be, problematic, a lot of the time. So whatever you can do to kind of get yourself in the right headspace before you deal with those individuals, right? Whatever it is that works for you, taking a deep breath, just, going for a brief walk outside the courtroom before you, head in, I think are just very, simple ways to kind of deal with some of this. And I just want to add, and hope you all know about the Illinois Lawyers Assistance Program, but just want to kind of just highlight them just briefly. They are a sister organization to the commission, do great work. I think sometimes we still only think of them in terms of, drug and alcohol issues, and obviously they do those and they handle those really well, but they really do great work, in just mental health issues in general, even anything from stress to, anxiety, etc. So they are a great resource. They have great materials on their website, and then they have, phone number as well. The great thing is there's Illinois Supreme Court rule. Everything needs to remain confidential. They cannot share, any of that information. And I will just add to the other thing, if you have an attorney that that is struggling, they are also very good with, if you want to talk through with them how you might approach such an individual, definitely a good resource for that as well. And so kind of as a capstone to our time together today, if you could put in, just a few words or one word to kind of sum up why lawyers should be civil, that would be great. I don't know the data on that, but that makes sense, right? So civil people live longer. Yep. Good manners. For sure. I think, yeah, and Mark highlighted that at the beginning. It's the enjoyment of work. I think when we read, I do a lot of well-being with lawyers. When I read why people are leaving the profession, a lot of these issues are really some of the main reasons. Yep. It's the right thing to do for sure. Yeah, love that. Just reminding oneself this is a job. Um, Yeah, I mean, and one thing we didn't with the professionalism too, one thing we didn't even address, which I think some of these probably get at is, I think as we all know, I mean, even in a big city like Chicago, word travels quickly as to who, which attorneys behave badly and poorly. And it doesn't take long for that word to get out. Yep. Yep, agree. Yep, where it goes around, comes around for sure.
Well, I love that professionalism is leading the word cloud as it should be. Thanks for everyone's participation and engagement, both in the chat and via Slido. We appreciate. And for those of you who are eating your lunch and otherwise, thank you for listening too. That's important. This is all important.
Yes, for sure. Thanks, Mark. And yeah, I want to say thank you too for having us, and for all that you all do to really make the profession one that we can all be proud of. Thank you for that. If you know when you want to connect with us, Mark's put the To Civility website in the chat at the beginning, tocivility.org. Here's our information and ways to keep in contact with us. I think the Civility and Courtroom is going to pop up while you guys are filling that out. I will also just want to highlight for you too that our Future is Now conference, this will be our 8th year doing this conference, will be April 24th, which is a great time right before the June CLE deadline for those of you who are in the latter half of the alphabet, as Mark and I are, with our deadline June 30th. This will get you 4 hours of CLE credit. It will include 1 hour of diversity and inclusion, 1 hour of mental health and substance abuse, and then 2 other hours. We have a great lineup that is really going to be outstanding. So it's a virtual conference. QR code is here. If you're not a QR code person, I can get the information to you or reach out to us as well. But really, thank you for your time today.
Yeah, if you went to our website, you can just go to the very top of our website and you'll also see a link right to it. Thanks, everybody. Pleasure to be here.
Thank you so
Thank
much
you.
for presenting. This was a great class and full of information. And for those who didn't see it in the chat, I will send the PowerPoint as a PDF afterwards.